Citizens can also influence the decisions made by the Supreme Court by voicing their opinions about who should be confirmed as a justice. Remember that the Senate is responsible for confirming each person the President nominates as a Supreme Court justice. Citizens can write, call, or email their senators to voice support or opposition for a Supreme Court candidate. In fact, young people are especially powerful when it comes to voicing their opinions and changing laws. For example, in 2017 the Florida legislature was considering a bill to outlaw distracted driving such as texting while driving. At the time, 20 students from Tallahassee Community College were studying the lawmaking process and decided to create a video that illuminated the issue of texting while driving. They were educating their local community about distracted driving and participating in the lawmaking process by supporting the distracted driving bill. The students were also exercising their right of free speech. However, as students, their rights, and yours, are different than an adult's. This is due to different court rulings such as the Vernonia ruling, the Earls case, and the Tinker case. These cases have worked together to form the basis of the rules you must follow. As the world changes, your rights while at school may change as well. As a student, and as a citizen, you do have certain rights, privileges, and freedoms. But, these rights and freedoms demand an equal responsibility. Speaking out against violations, obeying the rules, and working to enact change are only some of the responsibilities involved. If you commit a crime or violate your social duties in another way, your rights may no longer apply to you. For example, if you steal a car, your right to liberty could be suspended and you may be put in jail to await trial. The role of the Supreme Court. In 1968, 3 students in the Des Moines, Iowa school district were suspended for wearing black armbands in protest of the Vietnam War. School officials claimed the bands were disruptive and suspended the 3 students. They were told not to return to school until they could do so without their armbands. The children's fathers brought a case against the school claiming the students' First Amendment right to free speech had been violated. In 1969, the U.S. Supreme Court wrote, "The district court concluded that the action of the school authorities was reasonable because it was based upon their fear of a disturbance from the wearing of the armbands. But, in our system, undifferentiated fear, or apprehension of disturbance is not enough to overcome the right to freedom of expression. Any departure from absolute regimentation may cause trouble. Any variation from the majority's opinion may inspire fear. Any word spoken, in class, in the lunchroom, or on the campus, that deviates from the views of another person may start an argument or cause a disturbance. But our Constitution says we must take this risk." Termini LOV Chicago, 337 U.S. 1, 1949. And our history says that it is this sort of hazardous freedom, this kind of openness that is 509 the basis of our national strength and of the independence and vigor of Americans who grow up and live in this relatively permissive, often disputatious, society. The U.S. Supreme Court decision goes on to read, "In our system, state-operated schools may not be enclaves of totalitarianism. School officials do not possess absolute authority over their students. Students in school as well as out of school are persons under our Constitution. They are possessed of fundamental rights which the state must respect, just as they themselves must respect their obligations to the state. In our system, students may not be regarded as closed-circuit recipients of only that which the state chooses to communicate. They may not be confined to the expression of those sentiments that are officially approved. In the absence of a specific showing of constitutionally valid reasons to regulate their speech, students are entitled to freedom of expression of their views." As Judge Chewin, speaking for the Fifth Circuit, said, "School officials cannot suppress expressions of feelings with which they do not wish to contend." Burnside v. Byers, Supra, at 749. Tinker et al. v. Des Moines Independent Community School District et al. 1969. This decision made it clear that students do, in fact, have certain inalienable rights, even though they are inside a school building. Students have the right to free expression, provided it does not disrupt the functioning of the school's purpose, which is to educate. Further legislation has evolved which limits the type of freedom of speech, limiting obscene or vulgar speech as well as speech made at school-sponsored activities and in school publications, but the basic beliefs that students still have the right to express themselves freely tie back into the Tinker decision. Though the lawmaking process is intricate and detailed, it is that way for a reason. If it were easy to pass new laws, it could enable malicious politicians to pass laws that do not protect the rights of our citizens. Instead, The lawmaking process involves all three branches of government and has built-in processes that allow citizens to voice their opinions every step of the way.